So, first of all, I'd like to, thank the organizers for inviting me to speak. I should also make it clear that I'm not involved with the French Competition Authority. I just try to follow what it is doing. And when Paul invited me to speak at this conference, I realized quickly that I didn't really have a clue about the role of choice in French decisional practice. So I turned to more knowledgeable people, and including some members of the French Competition Authority, and asked them, okay, if you had to give a presentation about choice in French competitional practice, what would you say? And one answer that I got was, choice. Let me think. We might have mentioned it a couple of times, but the cases don't revolve around choice. This was something we added to make the decision look pretty. So really the question is choice really the cherry on the cake in France? And to look into this, I thought one could ask, when does choice really matter? It could matter at several different stages in the decision-making process. It could matter at the very general stage of policy design as a guiding principle. Preserving consumer choice would then be a goal. And I'll have an example to illustrate this later. It could also be taken into account at the stage of setting priorities, setting enforcement priorities. This, I think, is interesting, but it's not really a question for national competition authorities, as they have far less leeway. At least the French Competition Authority has much less discretion, in fact, no discretion, to set priorities. It has to take the cases that come. So I'm just mentioning it. And then, of course, consumer choice can be taken into account in actual decision-making in individual cases. And I'll take a few examples of that, where, and here it could still be relevant at different stages in a decision. At the stage, obviously, of defining the market, I won't dwell on this. Clearly, when you define a market, you have to either measure or anticipate how consumers will react to a hypothetical price increase, what choices they will make in reaction to that. Another possibility is for the authority to try and restore consumer choice when it feels it is threatened as a means to preserve competition. And I will also illustrate this. And another type of bearing that consumer choice can have is when the authority takes into account some properties of consumer choices, how consumer make choices, and this can be this can come up at various different stages in the decision. And lastly, consumer choice or interference with consumer choice could also be thought of as an element to characterize consumer harm. So I will not illustrate all these points, just a few of them by way of examples. So the first examples I'm going to take illustrate the authority, the French Competition Authority, trying to preserve choice as one of the goals of competition policy. And here I quote from a fairly recent decision. It was in a flour cartel, and the authority reasons that this approach, per se prohibition to horizontal, essentially price-fixing agreement, can be explained by the fact that such practices prevent undertakings that are party to the agreement from determining freely and independently the amount and destination of their production, from attracting consumers by lower prices, and, as a result, depriving them of the possibility of choosing between several different offers. Now, this is not a novelty, but it's interesting that the French authority, in a recent decision, felt the need to restate this rationale, quoting decision, an early decision from the European Commission from the early 70s, which used similar language. Now, when we read this passage, yeah, can you go back? Yeah, go back one slide, please. No, forward. One more, please. Okay. Thank you. When we read this passage, and I'm grateful to Daniel Zimmer for having the titles of our presentation shortened, because here also this is a point about consumer versus and firm's choice. My read in this passage we've just read, as you have noticed, it is about consumer choice and firm's choice. And it appears that because firm's choice is restricted by the agreement, they agree not to go into each other's market, as a result, consumer's choice is restricted. Now, where is the emphasis? My reading, but this could be discussed, my reading is that in Europe, there's a slight emphasis perhaps on firm's choice, and that consumer choice is of course important, but it's thought of as a result, a consequence of firm's choice being restricted, and that really matters. Doesn't mean that consumer choice restriction doesn't matter, but that's my perception of where the emphasis lies. Now, moving on to consumer choice as a decisive consideration in cases, I'd like to take two examples. Now, the first is a case from 2005, and the facts are as follows. You have this island, which is a few hundred meters away from Cannes, where the film festival happens, and the case is about the boat service between Cannes and this island. Now, on this island there is an abbey, and the whole of the island is private property of the abbey. And but the abbey welcomes visitors. It has a shop. It has a small hotel, and the island itself can be visited. And what started the case was that a boat company complained to the French competition authority that the abbey had set up a company and monopolized the boat service between the island and Cannes. And here I quote, it's my translation, as in all the slides, the complainant, who argued that users no longer have a choice between several companies and are entirely dependent on the Cistercian congregation for transport services. And interestingly, the authority held that there was a prima facie case of abuse of a dominant position, because effectively the congregation was exercising monopoly on an ancillary activity, ancillary here to the welcoming a visitor for just the visit. And it quoted EU case law on monopolizing ancillary activity. Then, but this wasn't enough to actually hold a claim, because, and this was actually why the decision was interesting, the authority ruled that in this case the conduct, monopolizing, was objectively justified, essentially because the market was so tiny, and the island, it was impractical to use other facilities, etc. The next case, however, was also about restoring choice for consumers, but this time it really worked. This was in December 2008, shortly after the release of the iPhone. And there was an arrangement between Apple and Orange, which is one of the 3 mobile telecom operators in France, whereby Orange would have an exclusive right to distribute the iPhone. So, and this agreement was concluded for a duration of 5 years, which is rather longer than was usual in the market. And as a result of this exclusive distribution agreement, consumers who wanted to purchase an iPhone had to choose Orange as a telecom operator. So this restricted their choice of operator. And because the authority felt that the iPhone was something so very desirable that consumers had to have the choice to have this phone without changing operators. And it felt so strongly about this that it granted interim measure. This is an interim measure case, and the exclusive agreement had to be changed. Then I won't go into this, but then the Cour de Cassation recently ruled on quashed the Court of Appeal judgment, which sustained these measures. But then again, the market, I mean, this had already produced its effects. Now, I'd like to turn on to a slightly more detailed analysis of also a couple of examples where the authority isn't only looking at whether the consumer can make a choice or how many options consumers have, but also at how consumers make choices. So this is again the French telecom markets with the 3 competing operators, and you see this lady, she walks past without looking. She probably already has a telecom subscription, and it's 24 months duration, so there's no way she's going to switch right now. And in another decision, this was also a horizontal agreement between the 3 telecom operators, and the agreement was called the Yalta of market shares, which aptly describes the purpose of the agreement. And what I find interesting in this decision is how the authority approaches the issue of switching. The decision reads as follows. Such developments are well known in relation to network goods such as mobile telecommunications, where, due to switching costs, it is important for each operator to attract at the outset sufficient installed base. Once this consumer base is constituted, consumers face switching costs which render them less mobile. From then on, each operator can exploit its network and practice high prices, thus taking advantage of its clients' reduced reactivity to changes in price. My own translation, but pretty literal. Now, in that decision, it was just one of several elements in the analysis about the intensity of competition. But what I find, yeah, if you can move to the next slide, please. What I find interesting is the issue of evidence. How does the authority know about sticky choices? Now, I'm not suggesting that this was a bad decision or that the holding wasn't justified, not at all. On the contrary, this holding was entirely consistent with the facts of the case, extreme complexity of price comparisons. There were so many variables, you couldn't very well compare prices at all among the various operators. A churn rate of only 10%, so quite low, and long-term contracts prevailing on the market, because in France, operators subsidize the terminal in exchange for long-term commitment. The question still arises, how does the authority know about how people choose? This may have been an easy case, but what about harder cases? And what I find interesting is that this passage is not worded as fact-based. Rather, it's authorities' notice, if I can make an analogy with judicial notice. It seems to be a well-known fact of consumer life that people don't switch. And this particular holding is consistent also with the teachings of psychology and behavioral economics, which have been mentioned. But then again, the question is, how about less obvious property of choices? Very quickly, another distinction which I found in an authority decision is the distinction the authority made between rational and emotional choices. The case, next slide please. The case was about detergent, and it was again a horizontal agreement. The main producers agreed on prices and reductions. And at the stage of market definition, the authority says you have to make a distinction between business consumers, hotels and the like, who buy detergents, and individual consumers. Why is that? Because consumer demand, says the authority, is influenced by subjective preferences and oriented towards well-known brands. And this implies, the logical connection is in the decision, high level of expenditure on brands, so that there's a distinct market segment characterized by high barriers to entry. Now, what puzzles me when I read this is how it is possible to say that it is because of consumers' taste for brands that companies have to invest in brands. Isn't it the other way around, that because the companies have invested over decades in brands, that they have framed the consumer choice in that way? So I'm not sure how helpful it is to think of consumer choice and consumer preference in the way, forgive me, in the way that economists do, taking preferences as a given. And to conclude and launch the discussion, what I meant to say was that choice issues, consumer choice issues, occasionally appear in French competition law decisions as a guiding principle. This was my first example. Also, at a more detailed level, as an element of appraisal, whether for the relevant market or for the object or effect of the practice. A little more detailed research would be interesting, I think, on this. And I have another slide of questions, really, that I'd love to discuss with you. Running through these examples made me wonder what type of interference with choices are relevant, and are relevant to what part of the reasoning in a competition decision. Deprivation of choice seems to be relevant to the appraisal of anti-competitive object and or effect. But how about less obvious interference, distortion of choice, illusion of choice when you have too many variables to actually choose, or impossible choices? Are these elements of consumer harm? I don't think the law is clear on that. And if we had to have a standard, this goes back to the question which was asked earlier, could or should the standards be that of genuine and manageable choice? I don't know. This is a question I'd love to discuss. Thank you.